welcome everyone. Thank you for joining us today in this session of the Oxford, Virginia Legal Dialogues. I'm Tsilly Dagan. I'm a professor of taxation law at Oxford University and one of the directors of the MSc in taxation at the Faculty of Law. And my co-convener for this workshop series is Ruth Mason, the Erwin S. Cohen Distinguished Professor of Law and Taxation at the University of Virginia, and the newly appointed director of the Virginia Center of Tax Law. Congratulations, Ruth. The purpose of this workshop, those of you who have been with us before would know, is to foster communication between tax scholars and non-tax scholars. I think by now you may be familiar with the format. Ruth and I invite a tax academic that we admire to choose a work for discussion written by a non-tax, academic that they admire. Then we invite the author of the work to discuss it with us here online. And all of our sessions are open to the public and available on YouTube. And to find out about upcoming sessions, you can join our mailing list or watch the social media announcement to get updated. So it's a really special treat for us to have here today Judith Freedman and Timothy Endicott to discuss Timothy's work on the value of vagueness. First, I would like to introduce our commentator, Professor Judith Freedman. Ruth and I are excited to have with us today, to have Judith with us today. And we're very pleased to welcome you, Judith, to the workshop. It seems like Judith needs no introduction to this audience, and yet, let me say a couple of words. Judith Freedman is an emeritus professor of taxation law and policy at Oxford, having been the inaugural professor of taxation law in the university between 2001 and 2019, an admired teacher and scholar. She still is very much a part of our tax research community. Judith's important work focused particularly on corporate and business taxation with a special interest in tax policy and design. She has written numerous pieces about small businesses, about the interaction between law and accounting, tax avoidance, tax and corporate social responsibility, and the use of discretion in the administration of taxation. Judith was one of the founders of the Oxford University Center for Business Taxation and its director of legal research. She also was the leading force in the setting up of the MSc in taxation in Oxford, and I can see many of our alumni with us here today. Judith was also one of the first directors of the program. She has served on numerous committees and advisory boards, and is still the general editor of the British Tax Review. And finally, to add to the many prizes and awards she has won, she was elected in 2016 as a fellow of the British Academy. So welcome, Judith. It's a real privilege to have you with us today. And Ruth and I were especially delighted that Judith wanted to discuss with us today the work of Professor Timothy Endicott, who is joining us today. Hi, Timothy, welcome. And again, another figure that needs no introduction, and yet just a couple of words. Timothy is the Vinerian Professor of English Law at Oxford and the University Academic Fellow at All Souls College. He is the former Dean of the Law Faculty for 2 terms, and also served as the general editor of the Oxford Journal of Legal Studies for 6 years. Timothy is one of the most prominent voices in constitutional law and administrative law and in jurisprudence, and has a special interest in law and language and legal interpretation. He is the author of numerous articles and 2 books, one on administrative law, and the other, the topic of our conversation today, vagueness in law. So it's a great honor to have you here with us, Timothy, and it's a great delight to welcome you two here today. So without further ado, I'm going to hand the floor over to Judith to introduce us with the discussion of the day. Thank you.
Thank you very much, Tsilly, and Ruth, for this wonderful series, which I have really enjoyed. I've watched a lot of them online. I've not always been able to join. And you're building up a great body of discussions and videos for people to watch. I think this is a really wonderful idea and shows how multifaceted the study of law and tax law can be. And I really want to thank Timothy for agreeing to join this group of tax people, which is very brave of him, but I'm sure he's going to do a fantastic job in guiding us through some pretty complicated ideas. It was his wise and calm writing which guided me when I was having difficulties responding to a particular line of comment that I was getting to work I was doing on tax, as I'll explain. And he has continued to be a great voice of reason as Dean of the Law Faculty, as well as in his writing. I'm really pleased that I've been able to choose his work to discuss, and I hope that many of you will, of course, already know about it, but it will also introduce his work to a wider audience amongst the tax community. Initially, I was going to talk about Timothy's book, Vagueness in Tax Law, Vagueness in Law, which is an OUP book, which was produced around 2000. But he suggested, and I was very happy to concur, that we used a chapter that he had later written, which synthesizes a lot of that work and results in a very, very rich, short but very rich article, which I hope people have had a chance to look at. And if you haven't, I really recommend it. It's based on his earlier book, but has developed some of the ideas, and in particular makes some more references to taxation. So that's very useful for us, although that wasn't the work I was initially using when I first used his work. So I will sometimes be referring to his 2000 book as well. Now, being an Oxford story, this connection between Timothy and me wasn't a straightforward one, of me going along to the faculty and meeting him. I was having lunch in my college with someone in the philosophy department, and he said, "Oh, don't you know that Timothy Endicott is working on exactly this problem that I was just trying to describe to him, and he's in your faculty?" And of course, I didn't know Timothy, and I didn't know he was in the faculty because that's the way Oxford works. But we get there eventually through the college system. And I started to look at Timothy's work because I was writing about the need for a statutory general anti-avoidance principle in UK tax law. But his ideas go far wider than avoidance. And I think one of the problems with this discussion in tax law is that we sometimes see it as only being about avoidance, but it's actually much wider than that in terms of how we should be drafting and whether we should be using principles or whether we should be aiming for precision. This is not something we should start with avoidance at. We should start with the basic drafting of our tax law when we think about how we design and draft tax law. But it is the preoccupation of most tax lawyers around this issue, anti-abuse. Now, this is quite strange because we have a lot of indeterminate concepts in tax law. For example, profit, the whole idea of profit. Outsiders might think that that's a very precise term, profit, and that it can be defined with one figure, but there is nothing more indeterminate than profit as a concept. Very few of us really understand what profit is, and definitely there's no such thing as true profit. And I think we're finding that with the recent discussions at international level. We can't agree what profit is. So that is a very indeterminate concept, and it's fundamental to tax. But initially I was looking at anti-avoidance, and I was looking at the relationship between rules and principles, or what in the US those of you from the US will think of as rules and standards. Now, Stanley Surrey had argued in 1969 that standards could reduce complexity in law, in tax law in particular, and David Weisbach at Chicago had argued in 1999 that this was the case in the context of anti-abuse. And later, in around the late 1990s, John Braithwaite, who is a regulation specialist from Australia, had begun to take an interest in tax, but also in how we write rules. And I was also influenced by Rob Baldwin and Julia Black at the LSE. So a lot of different influences and a lot of different people were thinking at that time about that relationship between rules and principles, and whether we could be drafting our legislation in a more principles-based way. And we ended up with Braithwaite, and I was very influenced by Braithwaite, who was arguing that rules alone could not give the necessary guidance because they needed context, and therefore we needed obligatory principles, non-binding rules, which is the other way around from the way theorists really often think about these things. They usually think of rules being binding and principles being overarching, but Braithwaite was saying that we would have a structure of obligatory principles with non-binding background rules and a regulatory conversation, and that was really Julia Black's contribution, a forum, a context so that people understood what those non-binding rules were all about. Now, UK tax law has detailed binding rules and detailed non-binding rules, and pages and pages of all of them. On the surface, therefore, we have plenty of precision. And actually, I was realizing that we had a situation where we had so much precision, but no certainty, very little certainty, just a cat and mouse game, which you'll all be familiar with, of finding the loopholes, stopping up the loopholes, using legislation to create some more loopholes. In fact, the more complex and precise the legislation was, the easier it was for clever advisors to find loopholes. And this is what Doreen McBarnett called creative compliance in her writing. So tax law seemed very much a candidate for reviewing the extent to which we wanted precise rules and the extent to which we wanted wider, vaguer rules. Now, the judiciary were busy developing their own vaguer approach in the so-called Ramsey principle, which it turns out, we now know, was always simply an approach to statutory interpretation and never a principle at all. But the limits and legitimacy of that were uncertain and remain uncertain. So I began to think about principles-based drafting, and in particular, whether we could have a principles-based statutory general anti-abuse rule that would reduce complexity, but not increase uncertainty. And the objection all the time was, that I was getting from anyone I discussed this with, was that such a principle would increase uncertainty and was a challenge to the rule of law. And Timothy's work provides a way of answering that problem. I was looking for some help with that problem. So the criticism was, and still is, that principles in general and a GAR in particular lack certainty, and that it follows from this that it fails to satisfy the rule of law. So I'm going to speak about my understanding of how Timothy's ideas helped me, and I may have completely misunderstood what he was trying to say, and in that case it will be a very useful opportunity for him to put me right. But this is how I've used his work, and I want to issue a disclaimer that his work is rooted in an enormous literature in vagueness, linguistics, philosophy. I know I've no more than scratched the surface. I've not read all the other philosophers. But at this point, I think I want to make a point more generally about interdisciplinary, or rather, multidisciplinary work that is encouraged by this series of seminars. It is inevitable that we will stray into areas on which we are not experts. And I have strayed into economics in my time, I have strayed into accounting, and I am now straying into philosophy, which seems very foolhardy, but we cannot do multidisciplinary work if we're not prepared to sometimes be looking a little foolish. And we have to hope that our colleagues will help us with lucid explanations like Timothy's and putting us right if we've got it wrong. So I feel I'm sticking my neck out a bit talking about philosophy, but I think that's something we have to be prepared to do, and I'm now old enough to cope with that. For those of you who are younger, well, just be brave. And I see Timothy's work as a very well-constructed bridge into the philosophy of vagueness, which makes it perfect for this seminar series. So Timothy's main arguments in his article and in his book, I think, are, first of all, that vagueness can be valuable to lawmakers. It can be a deliberate technique. We're not talking about accidental vagueness. We're talking about vagueness as a deliberate technique. And vagueness may well bring some level of indeterminacy about the law. That is, the law will not give one correct answer in every case. But it can also avert some of the forms of arbitrariness that come with precision. So precision can also result in indeterminacy or arbitrariness. Precision will be arbitrary if it prevents the legislation from achieving its objectives. So Timothy gives the example of defining an age below which a child must be supervised. If you leave a child at home, at what age do they have to be? And he says giving a precise age would not really give you a lack of arbitrariness, because there are so many variable factors as to what you should be taking into account. So that's an example of precision which could lead to arbitrariness, and I'll give some tax examples later. Then his third point is, so that's the second point, vagueness may bring indeterminacy, but it may be no worse than the indeterminacy you might get from precision. And it may not give rise to any more arbitrariness than you would get from precision. And then vagueness is not necessarily a deficit in the rule of law. It might be, but it's not necessarily a deficit in the rule of law. There's a balancing act to be performed in deciding whether the arbitrariness resulting from precision is worse than the arbitrariness resulting from applying a vague standard. It's simply a balancing act, as I see it. But it is not necessarily always the case that you will have more arbitrary results if you go for the standard or the principle rather than the detailed rule. And when we then look at the rule of law issue and try to decide whether there is a deficit in the rule of law, what we need to look at is whether there is a sufficient guide for people as to how to act. We can't expect the law to dictate an outcome in every case, but we can expect it to provide a guide. And it has to be possible to distinguish the reason of the law from the will of officials. So we cannot leave it simply to the will of officials to decide what is the law. But if there is some structure around the official's decision-making process, that may help to deal with any deficit in the rule of law. So just to elaborate a little more on those points and bring in some tax examples. As I've said, we're not talking here, when we talk about vagueness, about the kind of lack of certainty that results from an error. because the draftsman is sloppy. That's not what we're talking about. We are not all, I think Timothy does discuss in his book linguistic indeterminacy, but that's not really the focus of what I want to say today. So yes, it may be difficult to find words to say what it is you want to say, but we're here to, that's linguistic indeterminacy, but what we're talking about here today is legal indeterminacy, really deliberate use of concepts that may not be considered completely precise. So a precise rule, then this is Timothy's example, is one which sets a speed limit or a voting age. And he also gives us an example, a tax rate, and I'll come back to that. That would be a precise figure. They would often be quantitative rules. You can't vote if you are not 18. You must drive at 30 miles an hour or less. A vague rule might be one that refers to a broad descriptive term. And Timothy in his chapter actually gives a tax example. He gives the example of trade in tax law, a concept we're all familiar with, that's very important to us. And we could also refer to profit, as I've already done, and to employee, which I'm very preoccupied with at the moment. These are terms which are not defined with precision, but we use them quite deliberately. And then Timothy refers to the really extravagant and very common instances of vagueness in law. And we could use the term reasonable, for example. We find all of these in areas of tax law. Now, one question is there any reason why we should not use these as techniques in tax law just as much as they are used in every other area of law, tort, contract, and even in criminal law? If we think there is some special rule for tax, why do we think that tax shouldn't use these phrases just as much as any other area of law? And it would, I think Timothy makes a strong case in his chapter for saying that these are absolutely essential features of law. You could not draft law without some vagueness. So why is it considered to be such a problem in tax law? And that's just the question for the Q&A and for discussion. So going on to the problem of precision, just to give you an example, let's take a residence rule, a tax residence rule that simply used 183 days in a country as the rule. That looks very precise. It looks as if it's not open to arbitrariness, except that it obviously is, because we have to decide what amounts to presence in the jurisdiction, what happens if someone gets delayed or stuck, or there's a pandemic. But more importantly, it won't achieve our objectives very well if we only use 183 days, if we don't look at other factors such as whether the person has a home or family in the jurisdiction, whether they have other connecting factors. And if we only use 183 days, then someone who stays for 182 days precisely escapes residence. And in that way, we are coming up with a rule that may appear precise and not arbitrary, but which actually will be very arbitrary indeed, and will give quite a lot of scope to officials to argue, well, you weren't really here, or you were really here. So I'm not convinced that that simple quantitative test would give us a lack of arbitrariness or certainty. And if we move on to a concept like a trade or employee, would that make the application, would that be less arbitrary if we tried to define employee? And I've just been arguing with someone on Twitter this morning about how the definition of employee should simply be how long someone has had an engagement. And that clearly would not achieve the objectives of our legislation. We have to, and I think the big thing about all these areas is that they are very fact dependent. And in any area which is very fact dependent, any attempt at precision is going to lead to arbitrariness. And you could, for example, take transfer pricing rules as another example. Could we make them more precise? Yes, but would that make them better? I would suggest no. So the fact is that these are all dependent on all the facts. And in relation to tax avoidance, very detailed legislation will not give us more clarity. We will simply end up arguing about what particular words mean and may even lose sight of the objectives of the underlying legislation. So that brings us to the rule of law issue. How can we deal with the defects in the rule of law if we do have these indeterminate phrases or vague phrases? And applying the Endicott analysis, no one watching tax law could imagine that precision has resulted in certainty in our system. We spent last week hearing about our VAT regulations and how there was an argument about whether the size of marshmallows determined what the rate of tax would be, despite the fact that our VAT regulations are incredibly detailed. So what do we do about this? And how do we give certainty? And my argument around the general anti-avoidance rule, for example, is that although we use extravagantly vague phrases in the UK anti-avoidance rule, we use a double reasonableness test. We have two references to reasonableness, which might be considered to be very indeterminate indeed. What we achieve actually is greater certainty and less arbitrariness than just by leaving this whole area to the courts. Because the courts, if we don't have a rule, will attempt to stretch the law, will attempt to catch what seems to them evidently wrong. And we will have great uncertainty around what those particular words mean. Whereas if we have a general anti-avoidance rule which deliberately refers to reasonableness as a technique and uses vagueness, we can build around that a way of constraining the discretion of officials. And that is what we need to do to cure the defect, the result that might otherwise result in the rule of law. And that is exactly what we have done. Whether we've done it successfully or not is a question for another day, but we have attempted to do is build a system around the general anti-avoidance rule with safeguards for taxpayers, with a panel which creates a regulatory forum, a discussion forum, and with administrative rules that prevent officials from using the GAR simply at will. And that takes us back to Braithwaite's, my starting point with Braithwaite, that we have regulatory conversations with obligatory principles, non-binding background rules, and that gives us the best shot we have at legal certainty in complex situations. So that is how I have found the Endicott analysis so helpful in thinking about how we should draft our tax rules. Now Timothy can tell me that I completely misunderstood it, but I will still think those things. And he still helped me to think those things. So I'm going to hand over now to Timothy. Thank you.
Great. Thank you so much, Judith. And Timothy, the floor is yours. After Timothy will complete his remarks, we'll open the floor to comments, not before we'd let Judith reply briefly if she would like to. Timothy, please.
Thank you, Tsilly, and thank you so much, Judith, and I'm very glad to see you all. I find this very encouraging, actually, and you know, I don't think, maybe if I were a tax lawyer, there would be something in what Judith said that I disagree with. I didn't spot anything that I disagree with, and some of it I think is obviously really important, but I'm going to have some questions about it for her. When you do legal philosophy, I mean, I don't think it's just about the problems of vagueness, but perhaps philosophy in general. That you spend, you work. It's really hard, and you work hard, and then you find yourself thinking that it's all just trivial playing with words. And then at other points, you think it's so foundational that it's all that matters. And you have to deal with that. But there's a risk that you'll be thinking so deeply about the abstract foundations that you'll lose sight of what they are foundations of. So I think that legal philosophy has to be multidisciplinary in the sense that Judith explained. And that's why I just find it really encouraging. I found it encouraging when Judith gave her inaugural lecture in Oxford as the professor of tax law, that she was thinking about these problems. And I didn't realize when I wrote the article that Judith's been talking about, I hadn't thought through, I didn't have the wherewithal to think through the importance and the complexity of the problems. And I seized on tax in that article, because all of us know some tax law. I'd heard about income tax, as an example of the value of precision. And what I'd like to do in these brief remarks, having gone back to that article and read it, and the past is another country, so it's like reading something by somebody else who comes from another country, and rereading it that way, I'm kind of glad to see that I agree with some of what that guy wrote. But there's one sort of important point that I thought I might have articulated better, and that's quite important. And I wanted to comment on that, about the arbitrariness that comes with precision, because that's very important for what Judith's talking about. And then I would like to say a little bit about tax and revisit what I said there, and ask whether it was rash, now that I've got a better picture of the complexity. And then I'll come finally to some brief questions about what Judith has just said. The good thing about the article, I think, is that I focused on the arbitrariness that comes from precision, because and that I wanted to do that to try to shake up the idea that a vague rule leads to arbitrariness, and a precise rule removes the arbitrariness. And of course, you can see the attraction in the idea that vagueness leads to arbitrariness. Think of just looking at the examples that Judith has mentioned. I mentioned the minimum voting age in the article. Imagine we had a rule of maturity that you're entitled to vote if you've reached an appropriate level of maturity, or just if you're mature. And then, gosh, when you register for the right to vote, you're going to have to, some state official is going to have to pass judgment on your maturity. And there are a couple of problems with this. One is the allocation of power to the official, and that's why we think of it as arbitrary, because the mere will, the mere say-so of some official is deciding whether I'm mature, is going to determine my right to vote. And that allocation of power is a problem. And then we can remove that if they, I mean, we could remove it by just abolishing ages, but there's so many problems with votes for children in the way of potential for abuse and so on. And I don't know, I know some 8-year-olds, and I wouldn't want to be governed by the people they elect as representatives. So we want some sort of way as a community of bringing maturity to political deliberation. But speaking of children, it's so important, the role of children in the political community, that I think we need a voting age to protect them. And then we get away from the arbitrariness of the decision by some agency as to whether somebody's mature. And that prevents a form of power that's just liable to abuse, and not even just abuse, but just the risk is that the official won't be a good way on behalf of the community of deciding whether a particular person can vote. And finally, of course, when it comes to voting rights, it's actually specifically important that the community communicate to all its members that they're in to vote without the state passing judgment on them, except in respect of course, of passing judgment on how old they are. So there is an attraction to the idea that a precise rule can avoid an arbitrariness that comes with a vague rule that allows an application in a way that's more attuned to the underlying considerations. The underlying considerations are maturity and political deliberation. And if we simply had a rule that you have to be mature, that would allow the official to do just the right thing, sending away this 25-year-old, allowing this 12-year-old to vote when they can do a good job. So you see what I'm talking about. There's really good reason not to have a rule that imports into the community's decision the underlying considerations. But then, so I wanted to shake up the idea that vagueness is arbitrary, leads to arbitrary decision making, and precision replaces it with the rationality of rule governed decision making by pointing out the arbitrariness that comes with precision. But looking back on it, I think that there are two different sources of the arbitrariness of precision that are both sort of at play in the article, but I think it's worth distinguishing them. And I think they're both important in taxation from what I've learned from Judith. And there are actually two aspects of arbitrariness that comes with precision. And the first one is generality. And if you have a precise tax law that imposes a tax on income, well, the beauty of it is that it applies generally. And in order to secure the benefits of precision for rule-governed rationality and decision-making, it's got to apply generally. There's a requirement of the rule of law for you. And then if it applies generally, it's going to apply in cases where the taxpayer is doing just fine, and in cases where the taxpayer is struggling. And the taxpayer might be struggling in ways that are highly relevant to the underlying considerations in revenue, in state revenue, ability to pay, and the needs of the community for public revenue. Well, an income tax gives us a technique for precision, and any precise income tax imposes the revenue burden in ways that are different from one taxpayer to another, because of the taxpayer's circumstances, their family's needs, their own tastes, their other non-income resources, and so on. So there's a thing about a precise rule. It cannot pay attention to relevant differences in different cases, and that's in the article. But there's another thing that strikes me reading the article, which is regardless of generality, even if you have an entirely particular norm, you tell your 16-year-old she has to be home by 11 p.m. There's a precise norm. Well, and there's no generality to it. It's just this evening, this person has to come home at 11 p.m. It's not a general norm, and you'd be prepared to make a different norm in different particular cases. But you see what you've done by giving a precise time. There's ideally some correspondence between the time you've picked and the underlying considerations. But the underlying considerations are themselves vague. And you can imagine what they might be, together with to do with danger, with need for sleep, to be ready for whatever is happening tomorrow, all the other considerations, that those material considerations that determine when it's okay for the for the 16-year-old to come home, and when it's appropriate for you to say now and not then, all those underlying considerations, general moral reasons and general prudential reasons for action are vague. This is something I've found some fellow lawyers are shocked by this idea. Justice is vague as a general requirement of legitimate action by the state, but by you and me. Justice is vague. Justice might require compensation for tortious causation of a backache, and there is no precise amount that counts as just compensation. And if you start with £1, that's enough, not enough. If you get up to £1 billion, that'll be too much. And there is no rational answer to the question, what precise award of damages is just? Now, I venture to say, I don't know if Judith will contradict me on this. Here's one context in which precision really does have what you might call a general value: orders of a court. And an order of court that says the defendant must pay substantial damages to the plaintiff, that's a defective judicial order. We need a number that the law-abiding defendant can tap into the online bank transfer in order to satisfy the award of damages. So there's an example of a requirement of precision. Now, the underlying considerations, what does it take to give fair compensation for causing this backache? They're vague. The underlying considerations are vague. But as a matter of legal order, we need a number. Now, suppose so there's a virtue in precision in judicial orders. There's also some virtue in precision in tax. And what I hope we might be able to get at is what that value in precision is. And I do still insist, and as I suggested in the article, that in order to understand the value of precision, you also need to understand the arbitrariness that arises from it. And let's understand that as both the arbitrariness that arises from a general rule that cannot be sensitive to all the underlying considerations in different cases, but also the inevitability in giving a precise answer to a question as to what is to be done, of some failure to precisely track the underlying considerations because the underlying considerations are not precise. So I just wanted to say those things about the arbitrariness of that comes with precision. And then I wanted to revisit what I said about tax in that article. And here in our discussions before this, Judith sort of suggested that that I might have overplayed my cards when I said in the article that taxation gives the best possible example of the value of precision in constraining the officials. Let me read you what the article says about tax. Consider the difference. Now here, this in my defense, I think this is important because I think there is a worthwhile difference to notice here. Consider the difference between the law of taxation and the law of spousal support after a breakdown in a relationship. I wasn't specific, but let's think of it as support for a spouse who's bringing up children, or perhaps support for the spouse's own needs. And imagine a law that requires one spouse after a breakdown to support the other. Now, tax law generally uses precise rules, I naively said, requiring, for example, the payment of a precise proportion of income. That regime brings with it an important form of arbitrariness because some people on a higher income are less easily able to carry the tax burden than some on a lower income. That's the arbitrariness of precision that reflects the generality of rules. Assuming that the purpose of the tax is to share the burden of revenue in the community in a way that relates the burden to the ability to contribute, the arbitrariness of precision means that to some extent the tax cannot achieve that purpose. tax codes often try to cope with that form of arbitrariness by detailed rules allowing deductions for persons with dependent children, et cetera, those techniques are quite justifiable and can be quite sophisticated, but while complex rules on deductions can reduce the arbitrariness of precision, they cannot eliminate it. Moreover, their complexity itself runs contrary to what I call the normative principle, which is simply that the point of making a rule is for it to be capable of guiding conduct. And the complexity of the standards of tax law can make it difficult to some extent to use the standards as guides and to apply them. Judith talked about the complexity, and I didn't know enough about it to be more discriminating in the way I explain this problem. The arbitrariness that can come from complexity, the complexity that emerges if we try to achieve a fit with the underlying considerations by a multiplicity, by multiplying precise standards in the taxation scheme. So why not use a vague tax, I say? And here I offer one. The taxpayer must pay a proportion of income that is reasonable in the light of the revenue needs of the government and the taxpayer's circumstances. There's only one reasonableness test in there. And I say that a law like that would have the fidelity value of vagueness, fidelity, the value of the standard, the norm, the rule, whatever you want to call it, tracking closely the underlying considerations. That vague tax rule would allow the officials applying the tax to act in a way that's faithful to the purpose of the law by relating the burden of taxation to the individual conditions of individual taxpayers. And then I proclaim that such a law would, of course, be absurd and intolerable. First, because of the implications for tax administration, but also because however you run the administration of tax, it would leave taxpayers at the mercy of officials. And then I say taxation gives the best possible example of the value of precision in constraining the discretion of officials. Well, I think there's something to the contrast I draw with the law of spousal support. And I claim in the article that it wouldn't be wrong. If that would be wrong, that tax law would be all wrong. It wouldn't be all wrong to have a law that determines an obligation of spousal support by reference to what's reasonable in light of the needs of the spouse seeking support and the ability to contribute of the spouse who's being asked for support. And I still think that that's an important distinction, but I'm less confident about how I've explained it. And in particular, in respect of a general anti-avoidance rule, I guess I'd like to ask Judith to explain a little bit more about why a double reasonableness test in the regulation of measures taken to avoid tax does not lead to the sort of tyranny that I was suggesting in that article would arise from a reasonableness test in tax. So I'd like to ask Judith, where is the value in precision? I find something attractive in the actual numbers in the UK income tax and in the fact that you can type in what it says on your salary statement and on the website, and it actually tells you what the tax is. There's something attractive in being able to do that. Attractive in the sense of, well, in an emotional sense, actually, in the sense of my feeling that I'm not at sea and my grasp of what I'm up against. And of course, there's something valuable about it in rule of law terms, because it gives me and millions of taxpayers in this country it gives us a life that is governed in this pretty important respect in a way that's according to rules adopted by our parliament, clear, open, prospective general rules. So there seems to me a value in it. And I'd like to ask Judith if she can give any general description about the value of precision in tax law, given that I'm totally persuaded by what she says about how the arbitrariness of precision, the various forms of arbitrariness of precision, can actually create rule of law problems in a scheme that doesn't have a general anti-avoidance rule and tries to maintain a precision in all respects, multiplying complexity and complicating administration and making the tax more opaque to the taxpayer and creating the potential for creative compliance and so on. So I'm persuaded, and that we actually need vagueness in tax law. We need it in order to tax trades or adventures in the nature of trade, as the UK tax law used to put it, and then we need vague descriptions of the tax base, that which is subject to tax, and that's because human affairs are so complex. We need vague tax law, and it's an important point in Judith's inaugural lecture and in my discussions with her, that it's not just a general anti-avoidance rule. We need vagueness in the drafting of tax law. Okay, I'm one over, and then what is the value of precision? When should the lawmakers pursue precision in tax law? That's my question for Judith.
Thank you. Judith.
Do you want me to try and answer that? Not hard at all.
Like to, if you
well,
would like
I'm going. Yes, I will try to answer that. I think perhaps we are slightly at cross purposes, because in terms of which level we're looking at, because I obviously agree we have to have a rate of tax. We can't just say everybody should pay a fair tax. And so if we have wealthy people in the UK and we decide we want to tax them at 45%, not 40%, but 45%. And I think it's obviously essential to have that rate of tax. The problem is that then doesn't answer all the questions, because we don't know what we're taxing as income and what we're taxing as capital. And those are very vague concepts. So if I'm a private equity person and I have carried interest, I will argue that I should not pay 45%. I should be paying the capital gains tax rate. I should be paying 28% on that. So we have given some level of certainty and satisfaction by saying it's 45% for the standard in the center of the spectrum, but at the edges of the spectrum, we don't create certainty that way. And the other point that I would make about that is your court order point. And looking at your spousal support, I agree that spousal support can be based on an underlying notion of doing what you can for the person, for the family, giving a fair settlement, taking into account all the considerations. But at the point of the court order, as you yourself said earlier in your talk, you need a precise figure. The court will have to order a precise figure. And we have the same issue exactly in tax. We have a situation where there are many arguments about what is profit. There are many arguments about what the correct transfer price should be. But once we've had those arguments, and when the court or the official or whoever is deciding the issue comes to a decision, we do need a precise figure. So we do both need a precise figure at the end, but we also need underlying, sorry, that's my phone. I hope my husband's going to answer. We also need, answer it. Sorry. I'm going to stop it. Yes, so we have two levels. We do have the concept of how we're reaching that answer, by taking into account a range of considerations. And we have exactly the same in tax. We're taking into account a range of considerations to decide what the answer is. But then when it comes to the final decision, which has to be made by the court or the official, we do need a precise answer. So we need both. We need that level of precision ultimately, but how we get to that level of precision and the rules getting us to that level of precision, in both cases, I think, may be better rules and less arbitrary if they are more fact-based and take into account a greater range of facts. Does that make sense?
Yes, of course it does. I mean, and the point about the need for precision in court orders, that's true with spousal support as well, of course. So there are many contexts in which we need a decision, a resolution of a dispute that brings resolution, and resolution is only resolution involves precision in a sense, and general damages in tort is an example. The relevant considerations are vague. The court has not done its job if it gives a vague order. It needs to give a precise order. Likewise, spousal support, it's the scheme is defective if it yields a decision that that one spouse has to give substantial support to the other, and that's because of the need to rule, the need for the law to rule, to actually have conclusive effect in action, in the payment of damages in the tort case, in payment of support. And of course we could say in tax law, well, we need that, but we could still have vague standards, and then you get your precision at the end when you're in a dispute with the tax department. Then you get a court to issue an order that tells you how much you have to pay, and then that's where you get. Now, I agree that we need that precision at that point, and then but then at the earlier point, at the prospective point of legislating for tax liability, we also need forms of precision that we don't need in the spousal support case, I think. And you've pointed out something about that, Judith, that that we need precise tax on income if we have an income tax. We need a precise capital gains tax if we have a capital gains tax. And then there will be a need for the system to give up a mad imaginary impulse to achieve complete precision, because of the need to secure revenue in a way that involves both a capital gains tax and an income tax, in a context in which the actual activities do not allow a useful, stable, precise distinction between capital gains and income. So then I guess my question is, why was it that we need a precise income tax? I mean, and you can tell we're doing philosophy because this is obvious. It's just hard to say why. Why is that 40%, that number, whether it's 40% or whatever it is, why is it valuable to have that form of precision at the earlier stage that you've pointed out?
Oh, I think we need that precise number at the end of the process, because we need to know what we're liable to pay, but how we get to that precise number will rely on many imprecise discussions. And in another area of work I've done, looking at the relationship between tax law and accounting, we have a very good example of where in accounting you don't necessarily need a precise number at the end. You can have a discussion about what the profit is, and then you can have the profit presented in one way for one purpose, for paying dividends or for reporting, but when you come to reporting to the public, you may offer a range of figures because you can have notes explaining why you have a range of figures. But when it comes to paying tax on that amount, you have to have one figure because you simply need one figure to pay tax on. It's just a practical consideration. So there has to be a difference between the way we look at tax accounts and the way we look at financial statements, financial reporting. So I think both of them start with the same process, but tax does need to end with a more precise process simply for practical reasons. But in the same way, I think your spousal support example needs to end with a practical, precise figure for practical reasons.
That's right. Exactly. Yeah, I agree.
So thank you both. This was fascinating discussion. And although I know you could go on discussing with each other, I'd like to open up the floor for others to participate. And first, I'd like to turn to Ruth for a comment and a question. And while Ruth is unmuting, please feel free to raise your hands if you'd like to make a comment or ask a question. And also, I'd like to encourage you to use the chat box to present yourself, say who you are and where you're from. Ruth, please.
Great. So thank you so much. This has been a really rich discussion, and I've followed it closely. And I was thinking about, well, what is the principle we're pursuing in tax? And I mean, maybe it's something like, to support the revenue needs of the community, we should tax like community members alike. That's pretty vague. But at the end of the day, as Timothy and Judith have both been saying, we tax a number. We have to have a dollar amount that a person declares in their income that we attach a percentage to. And so that's a degree of, if we were aiming at the principle, we would want to know all the things that Timothy was talking about. We want to know the family situation. We want to know the earnings capability. We want to really know what investments, what capital the person has. But at the end of the day, we're measuring a dollar amount, and then we measure, because we need a precise dollar amount, we tend to look at what's convenient and easy to measure, and that's income from employment. And so we stray from our ideal, our principle, which is tax likes alike, and that injects arbitrariness, right? The getting from the principle to the tax liability. What we're demanding out of our tax system is just an unreasonable, unattainable task, right? To precisely measure this normative goal we're aiming at. And so maybe some of this arbitrariness is inevitable. You could perhaps make it smaller, but you can't get away from the idea that we can't really measure what we're after precisely. And I think you see this not only with, I was thinking about that in terms of individual income, but also, as Judith said, in standards like transfer pricing. We have a standard, the arm's length standard, or we have clear reflection of income or commensurate with income. We have these standards, right? And then we have regulations that are trying to help the taxpayer get from the standard to a number. But we say that the standard represents a range, a range of acceptable amounts that the taxpayer could declare, but at the end of the day, there's one number that gets picked, and so that feels arbitrary. So I don't know if that means that arbitrariness is worse in tax than it is in other areas, but I think it may be impossible to avoid all of it. What you see in the U.S. and elsewhere is that when you have a vague standard like commensurate with income or arm's length, then you have the executive, the administrative agency come in and engraft a kind of precision on top of these rules. So you have a vague standard, but then you have the executive say, okay, but if you do a cost sharing agreement in advance, we don't have to get into what that is, but just suffice it to say it behaves in a more rule-like, more precise standard to try to reduce the vagueness of the standard and give taxpayers some ex-ante certainty. And so, one question I have is, you might have thought that and this can go in either direction, right? The administrative agency or the judicial interpretation that comes later can either add more vagueness or it can add more precision. It can go in either direction. You know, I might have thought before this discussion that additional judicial interpretations or agency interpretations always add more precision because now we know more than we knew before. But the agency or the court could engraft a standard onto what otherwise looked like a precise rule. So, you know, for the US people, think about the Dormant Commerce Clause, you have a rule, no discrimination, and then the court engrafts eventually the undue burden standard onto this, right? And so it becomes a lot more vague. And so, you know, if that's right descriptively, like vagueness or precision can be added after the fact, after the legislature's already done. How should we think about that? Do we have a sense of how the three branches ought to be relating to each other on this? Do we have ideas about canons of statutory interpretation or concepts of deference to, you know, the legislature to accommodate right sizing of vagueness and precision? Well, should we be glad about changes in the degree of vagueness and precision to laws over the years? Or should we say, no, we shouldn't have that kind of discretion. We should just go with what the legislature wanted. And if the legislator got it wrong, then it's up to the legislature to fix it. And so, you know, I mean, in a sense, it seems like the law is kind of self-stabilizing with respect to vagueness or precision, right? That additional interpretations kind of help if the legislature got it wrong. But then I wasn't sure how I should think about that in terms of accountability. So that's like a new set of questions maybe to add to this already very rich discussion.
Thank you, Ruth. Judith or Timothy, would you like to reply? Don't feel like you have to. I mean, but if you would like to reply, then please do.
Well, just a brief comment on that last idea. Yeah, that's interesting, Ruth. We could think of it as certainty homeostasis. If we try to make the rules too certain, then well, there'll be the creative compliance phenomenon, but there'll also be the judicial phenomenon where the judges will start to find creative ways to avoid giving effect to precise rules, and we'll end up with a more or less stable amount of uncertainty in the system. I don't know. It will, of course, depend on the particular regulatory scheme or scheme of taxation. And the other idea in what you've and I think it was important in what Judith said earlier, and it's also in her inaugural lecture that that precision, and I know this is true in other areas of the law, that precise rules can lead to, well, what we might call equity in general. I know, or I assume, I don't know, I assume that I can't go to an English court and ask them not to apply these rigid rules because they're inequitable, and ask them to depart from the rules on grounds of equity. I don't think I can do that. But think of equity in general as a court's jurisdiction to depart from precise general rules, and there are areas of the law where there's a well-established jurisdiction for them to do so. In tax law, their impulse to avoid presumably to avoid inequitable implications of applications of precise rules will also affect the certainty that results from precision. You asked early in what you said whether arbitrariness is inevitable, and I thought arbitrariness is such an important idea and a rather delicate idea, because it sounds like it ought to be a pejorative. But maybe one result of what Judith and I have been saying is that, and perhaps you were suggesting this, Ruth, is that arbitrariness in the sense of departure from reason, that sounds terrible, departure from reason, but it may be necessary to depart from reason in one respect. In other words, not paying attention to the way one income taxpayer faces expenses that another doesn't. It may be necessary not to attend to those reasons, and there may be good reason for doing so. And then, is it arbitrary? Well, in a sense, yes, but not in the pejorative sense. if there's a reason of good ordering in the community, and avoiding making impossible distinctions and avoiding overcomplicating the tax code and the tax administration. If there are good reasons to impose a precise general rule, then it imports a form of arbitrariness, but it's not the pejorative kind of arbitrariness if there's reason for it.
Thank you. Judith, would you like to add to that?
I definitely think the courts can increase vagueness by adding precedents which raise further questions. So there is no doubt in my mind that you might have something that appears to be a precise rule, but then it will be argued by the lawyers in order to show that it is not as precise as we all thought it was. And that is in fact the lawyer's job, the advocate's job, to show that there are all sorts of other factors which should be being taken into account, and we will then have the judges commenting on that. And I have to give an example quickly from yesterday when I was sitting in court and thinking about this, because I was acting as a judge and looking at whether to give people disability benefits on the basis of whether they could walk 200 meters or not. And that is a very, very precise test. But of course, around that, we've had to bring in a regulation which says, can they walk repeatedly, safely, and without regularly? And then the courts have looked at that and said, well, that means should they be in pain, or should they not be in pain when they're walking, and so on? And should they have a stick, or can they have a stick or not? So something that started as very precise actually has then accrued regulatory complexity, and then further than that, judicial complexity, as we see how many different facts can underlie that decision. And it becomes less and less precise by people adding, in a way, it's less and less precise. You might say it's becoming more precise because we have more information, as you said, but it gives us more things we have to decide, and there is more discretion in the judges. Without any doubt, it gives us more discretion.
Thank you. Amanda Parsons, please.
Hi, thank you so much. I really have been enjoyed the conversation so far. I have a question about sort of how the value of sort of vagueness versus precision is impacted by the sort of dynamics of the specific institutions that are applying on the laws. And just to be a little bit more specific, so in the US, we do have some tax disputes that are happening in the courts. The courts matter, right? But a lot of the action is happening at the agency level, like as Ruth was noting earlier. And, with audit disputes, private letter rulings, and the IRS isn't actually bound by its earlier decisions, while the courts are, but the IRS isn't bound by its earlier decisions, right? It could apply a vague rule in one way to taxpayer X, and then the next day apply it in a different way to taxpayer Y. Then that's totally fine. And they actually often do that because of the this push and pull dynamic that happens between the IRS and taxpayers, as taxpayers are kind of like trying to engage in creative tax planning, push the sort of limits of tax law. And then this can also lead to like this, sort of an incoherent, kind of scattered regime, which is something that Kristen Hickman and Claire Hill really clearly laid out on an article a few years ago. And so I guess my question sort of boils down to, does the value of vagueness require decision makers to be, to at least some extent, bound by their previous decisions, or the previous decisions of their, within their institution?
Thank you. Timothy, Judith?
Can you help us with that, Judith?
That seems to be more a rule of law point than a vagueness point. I mean, to some extent, there has to be some way of arguing that these rules should be applied equally to different taxpayers, and if you found that they were being applied radically differently, then in the UK, you would presumably be able to have some kind of judicial review remedy, but only if you had standing and only if it was applied unreasonably in a non-legitimate way to you. So it would be difficult to find a remedy, but the aim must be to have some sufficient control of the discretion of the official to ensure that that does not happen on a whim, that there has to be a reason, and that they're working within some regulatory boundaries. But I think that's actually more for Timothy than me, because he's an administrative lawyer.
And gosh, as a matter of general administrative law, I think it's a extraordinarily difficult question to ask to answer. And I wouldn't say that administrative agencies should generally be bound by their past decisions, but I think it's a good general proposition of administrative law, including in respect of taxation, that that a court should have jurisdiction to give a remedy against failures of consistency in agency decision making that are unfair.
Thank you.
So there's, of course, there's something attractive to that idea, Amanda.
Thanks.
So I'm possible, just maybe, and I think complete precision is impossible, but that's not a bad thing. Complete consistency is impossible, but maybe that is a bad thing. I don't know.
Yeah, thank you. So I'm conscious of the time, and we have 4 questions, and I'm thinking maybe we should take them in pairs now before we turn to the speakers. So David Duff. Hi, David.
Hi, Tsilly. Thank you to you and Ruth for putting this together, and Judith, Timothy, good to see you, and thank you for the great discussion. As I reflect on vagueness, at times it seems as though Timothy is suggesting that vagueness itself is a virtue in the law, and I guess I wanted to probe that a little bit, because I see vagueness as inevitable, but whether it's a positive virtue, I'm skeptical about that. I think it's associated with other virtues, in particular fairness. So we need sort of more open-ended rules, reasonableness standards, anti-avoidance rules in order to ensure fairness that results in some vagueness. But the vagueness is kind of this unfortunate side effect to get the true virtue, which is the fairness. And then that raises questions, at least in my mind, and then that raises questions about how you can try to constrain that vagueness, particularly when if I come back to anti-avoidance rules, one of the huge challenges is when you've got very detailed statutory provisions for courts to go behind them and assess what the purpose of those provisions is in order to apply anti-avoidance rules. And it seems to me as though we could do a better job in tax law on that. That's partly, I think, when Judith talks about principles-based drafting, although I'm less certain it needs to be in the legislation as opposed to extrinsic statements of purpose, more robust statements than one often gets in from legislatures when they enact new legislation. Our Department of Finance, for example, issues technical notes that are almost a paraphrase of the legislation and therefore useless, really, for exploring the purpose. And providing more robust explanations of purpose behind detailed rules, I think, can constrain some of the vagueness around the application of anti-avoidance rules.
Thank you. Ted Sato. Hi.
Yeah, so there's a factor that hasn't really been raised, at least in this session, that I wanted to put on the floor, and that is the question of in what context are we giving the guidance and to whom? In U.S. private law, we have the concept of settlement in the shadow of the law, or compliance in the shadow of the law, and the notion is that we will try to structure the rules so that people can resolve their differences without involving the courts, because involving the courts is very, very expensive. And as a result, we end up with a lot of general legal rules with some elaboration by the courts, and then very specific ways of trying to resolve those things. For example, in California, coming back to Timothy's point about spousal support, we have very vague general rules, and then we have software. And the software tells you exactly what you have to pay. The software is not the law, but I would guess that well over 95% of all divorces use the software, and bingo, it's done. And that keeps the courts out of the issue. So in tax, we have a couple of different contexts. We have the very sophisticated, let's say, partnership or multinational context in which there are experts who can resolve issues in the shadow of the law, taking into account all of the stuff that's out there. And then we have the average taxpayer who maybe has the guidance from TurboTax or H&R Block software, but otherwise is just trying to, make April as unpainful as possible. And I think there, precision is really very important, and not just precision, but simple, understandable precision. So for example, this is a problem I'm working on right now. Are you married for tax purposes? There are two ways of doing this. You say, well, do you have a marriage certificate and in your state? And is that marriage certificate valid under state law? Really straightforward, okay? And that's, in fact, what we use in the United States. But there are other ways of doing it. With apologies to Australians, my understanding is that in Australia, the question is, are you in a marriage-like relationship? And you can just imagine taxpayers trying to figure that out and figure out whether they're in this regime for single people or in that regime for people who are in a marriage-like relationship. Again, it seems to me that in the context of filing initial return, there are very different considerations to be considered when we're in tax, when we're talking about individuals without legal advice, as opposed to, for example, the kinds of anti-avoidance rules that I think Judith was referring to in more sophisticated contexts.
Thank you. Timothy, would you like to comment on these?
Thank you. Briefly, in response to what you said, David, I guess I wanted to first of all, vagueness isn't intrinsically valuable. I guess I wanted to say that it's not necessarily best understood as an unfortunate side effect when there's a good reason to adopt it as a technique. And then it can actually be valuable. It's only valuable as a feature of a technique for securing some value, such as fairness. It can be inevitable and regrettable, or it can be something that the lawmaker should use, and then it's valuable in it as a technique. And of course, I do agree with what Ted Sato said, that the context of the guidance is crucial, and then my goodness, there can be a great distance between the vagueness or precision of the set of rules, spousal support or whatever, and what actually goes on, and what advice counts as good advice to the client. That can depend on a lot of matters involving enforcement and costs of process and costs of advice and so on as well. So I do agree that these rules that a lot of what goes on in the shadow of them, as you say, but then I think it can make a difference whether the shadow is sort of fuzzy or very sharply delineated.
Judith?
Okay, so I agree with what Timothy has just said, and I won't repeat those points. On David's purpose external to the legislation, the problem with that is then we get into hierarchies and which overrides what, and that's what discussions in the UK on purposive principles-based legislation has run into. That's very brief. It's a really interesting discussion. I can't go into it. And I agree with what context is, of course, important, and we do need some areas where we have simple rules so that the whole thing is workable. I'm on the board of the Office of Tax Simplification here in the UK, which has just been abolished in our mini budget. It's the only thing left from our mini budget, so it's pretty devastating. But I agree with that. But I do not agree, and I deeply disagree with you, Ted, that software can tell you answers. Software will never tell you answers. It's what's been put into the software. And if what's gone into the software is rubbish, then what comes out of the software is going to be rubbish. And if you don't have simple rules to start with, your software is not going to solve the problem. And that's exactly what's happened in the UK with our UK rules on in how we define employees. We don't have a clear definition, and but the revenue does have a tool which is supposed to tell you whether you have an employee or not. And the tool is rubbish because we don't have a clear underlying set of rules. So you rubbish in and rubbish out. So that would be my answer on that.
Thank you. Stephen Daly. Hi, Steve.
Hi, thanks very much. This has been absolutely fantastic. A great way to spend a Friday afternoon. Really love the paper, really love the discussion as well afterwards. It seems to me a lot of the discussion so far is focused on the substance of tax, and I think it's important to separate the substance from the procedure. I'd go all in and say actually all areas of tax in terms of the substance of tax rules are vague except for the rate, actually, except for the rate that Professor Endicott raised. If you look at the base, the rate, timing, unit, how you deal with intermediaries and the jurisdiction of tax, all these elements are essential to the substance of tax rules. I think there's vagueness inherent in all of those. But it's on the procedure, I would argue that you want to have precision. So when is a tax return due? When can a tax inquiry be opened? What's the limits on how long a tax inquiry can go on for? What are the precise rules around how you open an inquiry and so on? But although we have precise rules on that in the UK, some precise rules, other countries have more precise rules, it seems to me like the courts adopt a kind of Janus-faced approach, sometimes being very strict in how they interpret those precise rules and sometimes quite loose on how they interpret those precise rules. So coming back to a recent case where they did in fact use equity, Professor Endicott, you were joking about, you could go to court and say, this tax provision is unfair and I don't think it's equitable. But the tax authority does get away with doing that when it comes to administration. This administrative rule is very strict and it's resulted in an unfair outcome for us. Therefore, we shouldn't have to apply for it. And that worked in a recent case of Tinkler. They were required to send the notice of assessment to the person's address. They didn't do it. Supreme Court said it didn't matter because they relied upon the equitable estoppel by convention using equity. So I think that just the broad point I'd like to say is I think there's a lot that could be written also in this area around tax procedure and not just the substance.
Thank you. Luis Triggs?
Thank you for this. So I just trying to wrap my head around some of the points that have been made about administrative implications and the legitimacy issues that might be arising in terms of where the vagueness or the precision comes from. And it seems that actually until this just last question from Stephen Daly, most of the conversation has revolved around the guidance value of precision rather than what you call the process value, which I suppose in this context concerns how the precision of the rules or lack thereof affects the ability of the revenue authorities to administer the tax system. But in the face of vagueness, it seems often the response of HMRC is maybe to try and wrench us back towards precision by publishing guidance as to the interpretation of the substantive rules. And this is something that I think we see across a lot of different administrative law contexts. Immigration is probably a prominent example. And I'm aware that you say that the power delegation function of vagueness is the negative counterpart of that process value, but I suppose I'm just maybe prospecting for more detail there. I guess my question boils down to either in tax specifically or across administrative law as a whole, does a normative problem arise where a vague standard has been adopted to begin with, and then the administrators attempt to superimpose precision back onto it?
Thank you. So we're nearly out of time, but I would like to let Timothy and Judith take the time to respond to this. And if you'd like to say something briefly in conclusion.
Briefly on that last point from Lewis Triggs, I think it's hard to generalize it because, and I do think that it's a very significant technique of delegation to administrative agencies, vague legislation that they're responsible for implementing and applying. And then the the issuance of policy guidelines can be their way of exercising the power that has been allocated to them. And I don't think we can have any general answer to the question, well, is that a good idea? It may be terrifically useful, or it may be a tool of bad policy making or abuse, and it needs to be controlled, the making of policy, and it sure is in UK administrative law, my goodness. And then what Stephen Daly said, I talked a bit about civil procedure, and there's an analogy. I kind of think that it's good to have precise deadlines for filing something in civil procedure, and also in tax administration. I think that let me know that I've satisfied the requirement. But then it might also be good to have an equitable approach to failures, deviations, delays, late filings, and so on. And whether it's a good idea to have an equitable approach to the procedural requirements on the agency, that's a different question and too complicated for me. And maybe you're suggesting that they shouldn't get any equity. I'm not certain about that. I can't decide. Judith?
Well, yeah, Stephen, you've raised an area which is really big in the UK at the moment, with some very strange decisions emerging. But we do also have equity in favour of taxpayer with all the reasonable excuse cases. So it's a massive question, but really interesting, and to discuss it at some other time, I think. But it's a very interesting one. And Louis Triggs, I think that, I mean, as we said, as Ruth suggested earlier, guidance may try to give you more specificity, and less vagueness, but in doing so, it may actually add to the vagueness by adding all sorts of strange requirements. So you know, just back to the employee example, the UK guidance for lecturers and whether they're employed or not says, do you use your own PowerPoint machine, which is the most useless piece of information, I would say. But yes, that's put into the mix and makes it all even less certain, so can make it worse, and does need to be controlled, as Timothy suggests. Overall, thank you to everyone for all these great comments, and I'm going to go away and think about them all. And also to Timothy's really good presentation and comments. There's a lot to think about there, and I've really enjoed that discussion. So thanks everybody for being here.
Can I say thank you to Judith and Tsilly and Ruth and to all. I was a bit scared, but I've learned something. That's great. You know what I'd love, if it's technically possible, a copy of the comments in the chat. I don't know if that's possible. Thank you all.
It is possible, and we will forward them. So thank you both so much. This was a fascinating afternoon. Please join me in thanking Judith Freedman and Timothy Endicott. Thank you.